I see one over here. I see one over here. And there's got to be a third. Who's the third plaintiff's attorney? I'm not seeing a hand. Okay, I'm confused. Okay, well, we'll try. Who is designated as plaintiff's attorney number one?
I am, Your Honor. My name is Karis Hernandez.
Mr. Hernandez, thank you. And plaintiff's attorney two? Okay, I'm confused. Okay, well, we'll try. Who is designated as plaintiff's attorney number one? Okay, so I'm getting a delay from the YouTube channel. Someone has the YouTube up on their computer. I'll make sure it's not me. So hang on a second. I'm not seeing it up on mine. Did someone find that they had the YouTube channel up? Okay. All right. Who is considered plaintiff's counsel number two? All right. Can anyone hear me? All right. I know this gentleman. Oh, okay. So plaintiff's counsel, is it Mr. Briggs?
I am the defendant's counsel.
Thank you. You are one of the plaintiff's counsel, Mr. Zia Amati.
Yes, Your Honor.
Are you considered plaintiff's counsel 2 or 3?
I'm considered plaintiff's counsel 2.
Mr. Zia Amati, am I pronouncing your name right?
Yes, sir.
Thank you. All right.
Excuse me, Your Honor.
Third plaintiff's counsel is who?
Our third is Leticia, and she's waiting in the waiting room.
Okay, so Sunday is going to help us with that. Thank you. All right, we're looking for Leticia Innocente.
I'm here.
Hi, Ms. Innocente, can you hear us?
Yes, I can hear you.
Very glad to have you. So I was just getting the names laid out so I can sort of picture the courtroom, since we're all on different squares that don't kind of line up to where we would normally be in court. And I'm just trying to picture it as I would in court, okay? So you're plaintiff's attorney 3 and you are Ms. Innocente, is that correct?
Innocenti, yes.
Innocenti? Is that better?
Yes, perfect.
I don't want to get people's names wrong. Ms. Innocenti, thank you very much. I apologize if I messed that up a few times. I'll do my best, Ms. Innocenti. And thank you, plaintiff's counsel. And defense counsel, can I see we have 3 defense counsel? There's 1, there's 2. 1, 2, 3. Very good. We have 3 defense counsel. And defense counsel 1 is?
I am, Your Honor. My name is Zoe Mans-Jackson.
Ms. Mans-Jackson, thank you. Jackson. And defense counsel 2?
Jessica Bustillos, Your Honor.
Ms. Bustillos, thank you. Great. And defense counsel 3?
My name is Peter Briggs, Your Honor.
Thank you very much, Mr. Briggs. All right. Thank you for doing that. It takes a while, but it really helps me, and I think it helps the scoring panelists try to keep track of who everybody is as we go forward. My apologies for the background noise. We'll do our best we can. I tried to unplug everything I could, but apparently something's still plugged in. Sorry. And all right. On behalf of plaintiff's side, were there any preliminary matters before we go forward with opening statements?
Yes, Your Honor.
Okay, Mr. Hernandez, preliminary matters?
Yes, sir.
Is there anything you needed?
Your Honor, how do we exchange rosters so we get proper pronouns?
That's an excellent question that I've not been presented with. So I don't know that we're going to be doing rosters. If I wasn't told about sharing screens or doing other things to share rosters. I'm assuming we'll just proceed without it, and the witnesses will be clear about their pronouns as we go forward, unless our facilitator has a different idea, unless Ms. King knows a solution to exchanging rosters. That's not something I think was provided for, but Ms. King?
Yes, Judge, I will check with Mr. Downey right now and be back in just a second.
All right. All right. And other than exchanging rosters and providing a list of attorneys or list of evidence, again, because I don't think we really have provided for that here. Is there any other preliminary matter, Mr. Hernandez?
Your Honor, we request a court's preference on redirects and recrosses.
I'm sorry, you're requesting what?
Preference on redirects and recrosses.
I'm not sure what you mean by preference. I'm sorry.
When the time comes, we request that a redirect and recross is given. If so, does that?
That's a good question. I'll explain that to you. My practice is to allow brief redirect. Obviously, it comes out of your total time. I typically do not allow recross. If counsel makes an outstanding argument about why recross should be permitted, I will consider it. But typically, I allow 1.5 times around: direct examination, cross-examination, brief redirect examination. So I typically don't allow recross, and but I will automatically be allowing direct, cross, and redirect. Anything else, Mr. Hernandez, for the plaintiff?
Yes, Your Honor. Pursuant to Rule 7.4, when an exhibit or impeachment or refreshment or recollection or any document is shown, we request that a member of co-counsel screen shares.
All right, I think that's a reasonable solution. Again, we didn't talk very much in our discussion before trial about how that would be done, but that sounds to me like how it should be done. You know, in court, what we've been doing is we have electronic files. So with the electronic files, the parties are able to file their exhibits in advance on our electronic filing system. So we don't have to worry about screen sharing. But I think that that's a reasonable solution. As long as it sort of works for both sides. Is the defense going to be prepared as well to engage in screen sharing to show me certain exhibits?
Yes, Your Honor. We have no objection.
Thank you very much, Mr. Briggs. The court will approve screen sharing as the method to show myself and the panelists, as well as opposing counsel, the exhibits that you're presenting to the witness during the trial. Thank you. I hesitate to ask, was there anything else, Mr. Hernandez?
Yes, Your Honor. We recognize that the sound quality and internet connectivity may vary and be lagging at times. So we ask that the court pause proceedings to allow witnesses or to repeat questions or answers if internet does become an issue.
It's apropos that you brought that up because I was having a little difficulty with some stuttering of your audio and video a few moments ago. So it does occur to me that if a scoring panelist or myself has an issue, we will try to ask something be repeated. In terms of how that's going to work with the timer, I think that the timer should be willing to stop and restart the timing for anyone when the court is asking something to be repeated because of technical issues. So for purposes of this, my hope is that the timers will accommodate us so that we're not spending a lot of time in the trial dealing with technical problems that go against your time. I don't think that's fair. So very good point. Anything else, Mr. Hernandez?
Yes, Your Honor. That timekeepers be allowed to post remaining time throughout the trial.
How does that get posted? All right.
The chat function, you can chat to everyone.
Okay. That's an example of you were freezing and I'm having a little difficulty with your audio going in and out. So let me have a defense team member, Mr. Briggs. How does the time get posted during the trial so that you can see it, I can see it?
That would be through the chat function. There should be a box on the bottom of your screen that says chat, and the timekeepers will post it there.
Excellent. All right. Any objection to utilizing that that process?
No objection, Your Honor.
All right. And the time remaining and all of that is universally posted under everyone. It's not private to a particular individual, correct?
Yes, Your Honor.
Correct, Mr. Hernandez? Okay. Very good. All right. That works. Anything else, Mr. Hernandez?
Yes, Your Honor. We request remaining time for prosecution closing argument be reserved for rebuttal.
Okay, again, that's a timekeeper function, and you're going to request that the timekeeper let the parties know clearly how much time is left prior to the start of closings.
Could you repeat that, Your Honor? Yes.
What are you requesting we do, Mr. Hernandez, regarding this timing problem?
After we request that any time left we have for our closing be used for rebuttal after defense closing.
Absolutely, yes. That's granted as well. Anything else, Mr. Hernandez?
Your Honor, for the layout of attorney 1, 2, and 3, is that in terms of, is that in order of in how we're going, or just in general 1, 2, and 3?
It doesn't have to be the order in which you're going.
Okay.
I wanted to be able to sort of just picture you. I don't think you can see my screen when I do this because of the virtual background. I just put down on a yellow pad. There it is. I just put down on the yellow pad a layout of my courtroom, and I wrote your names where you'd be at the desk. And that will help me remember who all of you are when you do different witnesses and so forth. So I understand attorney 1 may or may not be doing opening for the plaintiff. I understand all that.
Mm-hmm.
I just kind of want to lay it out. Thank you. Anything else, Mr. Hernandez?
Your Honor, would you like to, after defense preliminary, would you like us to do introductions to know who we are and what we're doing and stuff like that?
I think due to the timing, we might skip that.
Okay.
And the way to make sure we know is to, again, announce yourself before your opening, announce yourself before you start your direct examination. And for defense, initially, you're announcing yourself before you cross-examine. I am Attorney Inocente, and I have these questions for you, or whatever. You can just start your questioning. So that will remind us so that when we're filling out our sheet, we're clear about who's doing what. But I think we'll kind of skip that. If you want, we can ask the witnesses to identify themselves in the order that they will appear. So we may do that. Defense have any other issues or concerns about introductions?
We have no objection to this.
All right, thank you. Anything else, Mr. Hernandez?
No, Your Honor, no further preliminary matters.
All right. Any other preliminary matters, Mr. Briggs?
Yes, Your Honor. For the purposes of this virtual competition, may we publish to the jury, opposing counsel, and Your Honor, the stipulations and our trial roster, which should be accessible to you?
Yes, and that's going to be done by screen sharing?
No, I would just like it to be published so the jury has permission to view those documents from their trial notebooks.
That's granted.
Thank you, Your Honor.
Any other preliminary matters, Mr. Briggs, on behalf of defense?
Yes, Your Honor. Although the rule of the competition 5.1.1 requires attorneys to stand during opening statements and closing arguments, because we are virtual, we ask that the court waive that requirement for both teams.
Yeah, I already sort of telegraphed that to everyone because I didn't ask you to stand for the oaths because then I wouldn't have seen anybody. So I didn't want to give an oath to your belly buttons, so we didn't do that. And we're going to, unfortunately, not be able to simulate that part of the trial. But in fact, this is exactly how we are doing teleconference trials. The attorneys are asked to remain seated. The witnesses, of course, are always seated. And this is as close to a simulation about how court is currently operating as you're going to see. So yes, attorneys certainly remain seated even for openings or closings. If someone is more comfortable, tilting the camera up, standing, using their hands or whatever it is that you think adds to the drama, I leave that up to you. I'm not going to tell you not to, but no panelist or judge is going to fault you for remaining seated during the parts where normally you would be standing, because we're just not going to be simulating that. Very good question. Anything else, Mr. Briggs?
Yes, Your Honor, we have one final matter.
Okay.
The defense would make a motion in limine pursuant to Rule 5.3.3 of the competition. We ask that the court exclude all testimony from witness Jordan Markowitz commenting on the defendant's attorneys canceling an interview with the detective. The grounds would be that this is an inappropriate comment on the defendant's right to remain silent.
All right. And do you feel that this is more appropriately, so this is appropriately brought up as a pretrial motion in limine as opposed to an objection if the witness were to testify?
Yes, Your Honor, and such a pretrial motion is permissible under Rule 5.3.3.
Thank you. And who from the plaintiff side is responding to this?
Me, Your Honor.
And this is Ms. Inocente?
Yes.
Okay. There's a bit of a delay, so I'm sorry. Ms. Inocente, your response, the motion is that you not be allowed to get into the fact that there was an interview where the witness apparently immediately said, I don't want to speak with you, something like that. Go ahead and respond.
That'll be fine, Your Honor.
So you're not objecting to that. The plaintiff agrees not to get into that interview in the case, correct?
Correct.
All right, thank you very much. The court agrees to grant the motion in limine over no objection because it would arguably comment on the witness's right to remain silent and potentially be a Fifth Amendment violation. So that's granted. Anything else, Mr. Briggs?
No, Your Honor, the defense is prepared.
All right, very good. And plaintiff side ready to begin their, let me make sure I have the team codes right. I'm sorry. And the plaintiff's team number, we don't go by what school and those things, we go by a team number, a team code. What is the plaintiff's team code, please?
We are team 4, Your Honor.
You're team 4. All right. Plaintiff is team 4. And Mr. Briggs, defense team number?
Defense's team number is number 7.
Thank you very much. Okay. And we will then begin with the opening statement for plaintiff. And this is going to be hi, opening statement for plaintiff. Who's giving that statement? Mr. Hernandez. Go ahead when ready, sir.
Your Honor. Your Honor, opposing counsel and members of the jury, it is the thought that counts. On the day of the murder, March 6, 2020, Avery Becker legally entered Mackenzie Brackman's home with the intention of not only breaking something up, trashing it, and in. I'm stable. Can you hear me?
All right, we're going to pause for a moment. We're having some Zoom difficulties right off the bat.
Yeah.
And I think that the rule is we're trying to get as many individuals off of video as possible so that we aren't using too much bandwidth. Thank you, Mr. Zia Amati. And we're going to try again. I heard your first opening statement, and continue, Mr. Hernandez.
Thank you, Honor. Avery Becker illegally entered Mackenzie Brackman's home with the bad intention of not only breaking in, but messing up the place or trashing it. She had unknowingly broken into the home while Mr. Brackman was still in the house. There is a conflict between the two, and eventually, Mr. Mackenzie Brackman was stabbed in his own home. Although she did not intend on killing her former coach, she went to the home with bad intent. It is the thought that counts. Today, we are here to charge Avery Becker with the murder of her former coach. Although this is an accusation, we know that after the trial today, through the evidence brought out and through our 3 witnesses, Detective Jordan Markowitz, Alex Fuentes, and Kyle Kuzak. Let's go ahead and talk about the time leading up to the murder of Mackenzie Brackman. Mackenzie Brackman was a coach for the Colorado High School mock trial team. Mr. Brackman was also an attorney himself. In general, he was doing well enough for himself to have his own Porsche. One of the members of this club was Avery Becker. Avery was generally pretty good at the club, but she lacked work ethic. She would often go in and improvise, and because of this, the two would often clash about what should have been done. Mr. Brackman thought it was better to be completely prepared and not leave things to chance. After too many mispractices, Mackenzie Brackman decided it was best to kick Avery the 8, and after a talk with her friend Taylor Perkins, she convinced Taylor to the team so that Mr. Brackman was forced to put her on the team. Pushed the limits between the two during their big competition. Avery had improvised and strayed from the script. Although the team, Mr. Brackman was not happy with her action. He believed that she left things too much up to chance and that it would the rest of the team. After the two exchanged unpleasant words, Avery left practice in anger as she didn't like the interaction between the two. There she saw Mr. Brackman's white Porsche. After she left the practice, she grabbed a marker and wrote "Worst Attorney Award" on the hood of his white Porsche. After that, Brackman walked out and saw her abandoning his car. And he her doing so. He kicked her off the team after the incident. Days after the incident, Avery attempted to contact Mr. Brackman, but with no success, which made her angry that Mr. Brackman would not talk to her or let her on the team. She even attempted to talk to another member of the team, Alex Fuentes. Alex Fuentes tried to talk to Brackman, but it didn't work. And Avery became more frustrated that Mr. Brackman wouldn't let her on the team after Alex talked to him. After Alex had told her this, Avery became even more frustrated and texted Alex about her plan to break in and vandalize Mr. Brackman's home. After Mackenzie Brackman was murdered, an investigation was conducted with Detective Jordan Markowitz and crime scene reconstructionist Kyle Kuzak to find out what happened and who killed Mr. Brackman. Through the evidence found in the home, as well as evidence given to them by Alex Fuentes, they found that Avery Becker is the murderer of her coach. Today, we have the burden of proof to show beyond a reasonable doubt that the defendant today, Avery Becker, committed first-degree murder as well as second-degree burglary, and we accept that burden today. We will prove it through our witnesses. Today, we have 3 witnesses. Our first witness, Detective Markowitz, will attest to the crime scene the day of the murder. She will also attest to the detective's reasoning to get to the conclusion that Avery is the murderer of Coach Mackenzie Brackman. Our second witness, Alex Fuentes, will attest to the relationship between herself and Avery Becker. She can also attest to Avery's behavior in the club. And our final witness, Kyle Kuzak, will attest to the crime scene evidence as well as a more detailed conclusion on what happened in the house between the intruder and Mr. Brackman. Whether it was a mistake or not, it is the thought that counts. And we know that after the case today, through the facts presented and the witness testimonies, that you'll find Avery is guilty of first-degree murder of her former coach, as well as second-degree burglary of Mackenzie Brackman's home. Thank you, Your Honor.
All right, thank you. One moment before we go to the defense opening. Just give me a moment. All right. And I will confirm that the panelists are ready to proceed to the next step.
Yes.
Thank you, Mr. Cassens. Thank you, Mr. Shoemaker. And we'll proceed with the opening remarks on behalf of defendant Avery Becker. And this counsel will be?
Peter Briggs, Your Honor.
Thank you, Mr. Briggs. Go ahead.
Your Honor, opposing counsel, and members of the jury. Avery wasn't there. She and Taylor were looking everywhere. On the morning of March 6th, Avery Becker awoke to the startling realization that her phone was missing. And so while someone else was killing Coach Brackman, Avery was with Taylor Perkins searching for that phone. They went nowhere near the Brackman residence, and Avery did not kill her late coach. The burden of proof today lies with the prosecution. They must prove to you beyond a reasonable doubt that Avery Becker, on or about March 6th, broke into the residence of Mackenzie Brackman with the intent to cause criminal mischief and thereto cause the death of her late coach. However, this burden exists because the law demands that juries assume every defendant innocent until proven guilty beyond a reasonable doubt. And at the close of the evidence today, you will find that this proof is non-existent. We, on the other hand, as the defense, have no legal burden of proof tonight. Nevertheless, we will still show you the innocence in the courtroom today by highlighting a lackluster police investigation riddled with mistakes and assumptions. You will hear from 6 witnesses, 3 from the prosecution and 3 from the defense. The prosecution will bring you Kyle Kuzak, a crime scene reconstruction investigator who, as a civilian consultant to the police, will tell you a story, but will provide no evidence linking Avery to that story or to that crime scene. You will see that only through a series of assumptions is Avery held at fault. The prosecution will also question Detective Markowitz, the police officer charged with investigating this murder. Markowitz will insist that cell phone tower data places Avery's phone in Brackman's neighborhood, but will provide, again, no evidence proving that Avery's phone was on her person, that they were in the same location whatsoever. Finally, the prosecution will question Alex Cifuentes, the former teammate, former class member of the defendant. With a clear bias against the defendant, Cifuentes has failed to provide their phone for the official police investigation, and therefore any evidence derived from this phone should be taken with a heavy grain of salt. As the defense, we will also present you with 3 witnesses, starting with Blake Van Owen, an expertly qualified private investigator who will outline the many ways in which digital image can be altered, underlining why Alex Cifuentes' evidence should be questioned. Blake Van Owen will also highlight the assumptions made by Kyle Kuzak in his conclusions and the many mistakes committed by Detective Markowitz in the official police investigation. Further, Van Owen will introduce us to an alternate suspect named Blair Rollins, who has since disappeared, has a strong motive, and went relatively uninvestigated by the police. As a defense, we will also bring you Taylor Perkins, who will corroborate Avery's alibi. Not only was Avery searching for her phone when Brackman was killed, but Avery was with Taylor. This testimony will cement in your minds Avery's innocence before we even get to our third witness, Avery herself. When the defendant takes the stand, she will describe to you in detail her activities the day of the murder, and she will explain how she lost her phone. She will also describe the true sentiments between her and her coach, dashing any motive proposed by the prosecution. The prosecution will use the creativity of Kyle Kuzak to cover a lackluster police investigation, using assumptions to fill holes where facts are missing. But don't let this fool you into perceiving a coherent story. The defense witnesses, on the other hand, will present a cohesive, unified front, centered around the simple fact of the corroborated alibi. At the close of the evidence today, my co-counsel Jessica will implore you to reach a verdict of not guilty. Because the prosecution, the assumptions and the mistakes that form the foundation of the prosecution's investigation and their case will be apparent, and the defense will have revealed the truth of the events on March 6th and shown the innocence in the courtroom today. Simply put, there will not be enough proof to convict this high schooler to a life of prison for a crime she didn't commit. Because members of the jury, Avery wasn't there. She and Taylor were looking everywhere. Thank you, Your Honor.
Thank you, Mr. Briggs. All right. And plaintiffs, go ahead and call your first witness.
Your Honor, my name is Letizia Innocenti. I would like to call Detective Jordan Markowitz to the stand.
Thank you very much. Detective Markowitz, you've previously been sworn. And Ms. Innocenti, you may go ahead.
Please state your name and spell the last for the record.
That's Detective Jordan Markowitz, Markowitz.
And tell us, how are you connected to this case?
I am here to testify on behalf of the prosecution for the trial of the death of Mackenzie Brackman.
And what is your profession?
I am a homicide detective with the Denver Police Department.
How long have you worked there?
Roughly 13 years.
What is your area of expertise?
I received specialized training from the American Academy of Law Enforcement regarding cell phone technology and forensic data recovery.
Cell phone technology?
Yes, how to interpret and understand cellular records and tower data. I've done this in over 50 cases.
Your Honor, pursuant to Rule 702, based upon their knowledge, skill, and experience, I am entering Detective Jordan Markowitz as a qualified expert as a homicide detective in the field of cell phone technology and forensic data recovery.
Any objection from the defense to the court accepting this witness as an expert?
Permission for a brief voir dire, Your Honor.
Granted.
Okay. Good evening, Detective Markowitz. My name is Jessica Bustillos. You're a homicide detective.
Yes.
With the Denver Police Department?
Yes.
The Denver Police Department is called by many DPD.
Yes.
You've worked with the DPD for 13 years.
Yes.
And as a detective for 7 years.
Yes.
You feel qualified as a homicide detective.
Yes.
Because you've done so much training to be a detective.
Yes.
And you've worked in the field for a while.
Yes.
In order to become a detective, you had to study for years.
Yes.
People who don't spend time in training are less qualified for the job.
Yes.
In fact, that applies to any job.
Yes.
You wouldn't trust someone who only had 3 days of training.
I guess so.
Is that a yes?
Yes.
Because to become skilled at a trade, you need more than a few days of training.
Well, yes, but I've also had years
That's a yes?
of experience. Yes.
You are new to cell phone technology
Yes.
and forensic data recovery.
Yes.
And when you became certified with only 3 days of training,
Yes.
which you admitted earlier wasn't sufficient.
No, I mean, yes, I did say that,
So that's
but
a yes?
yes.
I'm sorry about my background. Your Honor, I object to this witness being entered as an expert in cell phone data recovery, just because the witness themselves admitted that they didn't feel that they were qualified with just the initial 3 days of training, and that they were still new to it and didn't have the experience. And since you need experience to become qualified.
Before I ask for a response from the other side, I'm actually going to allow the detective to finish her answer about why it's not only about the days of training. So she attempted to fill in a little bit about that. Detective, you can complete that answer if you wish.
My years of experience do exceed my 3 days of training in cell phone technology.
All right. In response to the argument, the objection to the witness being qualified as an expert, Ms. Inocente, if you want to say anything else about that.
Yes, Your Honor. Rule 702 clearly states that an expert witness may be qualified by knowledge, skill, and experience. Detective Jordan Markowitz has worked for the DPD for 13 years and has been an investigator for roughly 7. They have worked in over 50 cases with cell phone technology, and we feel this qualifies them.
Oh, and a brief reply, if you wish, Ms. Bustillo.
Your Honor, I'm not objecting that she be entered as an expert as a detective, but I am objecting that she be entered as an expert in cell phone data recovery and in cell phone technology and forensic data recovery.
The objection is well taken, and I think well argued by both sides, but the court is going to allow the detective to testify based on education, training, and experience. The court finds it reasonably sufficient to allow the witness to testify as an expert in that specific field. I'll allow it. You may continue, Ms. Inocente.
Thank you, Your Honor. Detective Markowitz, what is your relation to Mackenzie Brockman?
I was assigned to investigate the death of Mackenzie Brackman in March of 2020.
Could you elaborate on that?
On March 6th, 2020, a dead body was reported on the porch of 444 South Flower Street. The officers secured the crime scene and I responded at approximately 14:20 hours.
Let the record reflect that I am showing opposing counsel what has been marked as exhibits 1, 2, and 4. Permission to share screen.
Granted.
Detective Markowitz, do you recognize this image?
Yes, this is one of the pictures of the dead body that belongs to Mackenzie Brackman.
Is this a fair and accurate representation of the body as seen from outside of the home?
Yes, it is.
And do you recognize this image?
This is also the dead body of Mackenzie Brackman from inside of the house.
And is this a fair and accurate representation of the body's position within the home?
Yes, it is.
Do you recognize this image?
Yes, I do.
Is this a fair and accurate representation of Coach Brockman's wounds?
Yes, it is.
Your Honor, we move to admit exhibits 1, 2, and 4 into evidence.
Any objection?
No objection, Your Honor.
All right. Court allows admission of 1, 2, and 4.
Your Honor, move to publish to jury.
Granted.
Detective Markowitz, could you describe the crime scene?
Yes, I can. The front door was open and the victim, Brackman, lay face down on the floor. Next to his body was a knife. The shirt he was wearing is blood-soaked, and the victim had clearly been stabbed. The angle of the pictures taken shows that he was most likely stabbed attempting to leave out the door.
And what was your first impression on the house?
The residence had multiple Ring doorbells, one facing the back gate and one facing the back door. The side gate was open and I entered through the back door. In the kitchen, there was a drawer slightly open full of knives, and in the living room, there was a chair knocked over and a broken plate on the floor. Drops of blood were clearly visible as well.
Let the record reflect that I am showing opposing counsel what has been marked as Exhibits 7 and 9. Permission to share screen.
Granted.
Do you recognize this image?
Yes, I do.
Is this a fair and accurate representation of the broken plate which you just described?
Yes.
Do you recognize this image?
Yes.
Is this a fair and accurate representation of the drawer of knives exactly how you found it upon entering the home?
Yes, it is.
Your Honor, we move to admit Exhibits 7 and 9 into evidence.
Any objection, Ms. Bustillo?
No objection, Your Honor.
7 and 9 are admitted.
7 and 9, Your Honor.
I'm sorry, what did I say? 7 and 9 are admitted.
Your Honor, move to publish to jury.
Granted.
Were you the only one at the scene of the crime?
No, I was not. The forensics team was also there processing the area around the body. Unfortunately, some of the data they created was unattainable.
And what did you do next?
Well, I looked around the house and I didn't find any other victims, and no objects had been stolen or otherwise disturbed. In my expert opinion, it would seem that the victim had caught someone breaking in and had confronted them with a knife in the kitchen. The intruder then must have stabbed the victim. Based on the intruder's attire, we can infer that they had malevolent intentions going into the home in this case.
Objection, Your Honor. Narrative.
All right. Response?
Your Honor, I can rephrase the question if you'd like.
All right, go ahead.
Detective Brockman, you mentioned something about intentions. Could you elaborate on that?
Well, it was clear, or excuse me, so sorry. We can infer that they had malevolent intentions going into the home. In this case, it is the thought that counts.
And did you recognize the victim immediately?
No, I did not. The victim was face down on the floor and I didn't get a good look at them until I saw their ID. I then realized that it was Mackenzie Brackman, a criminal defense lawyer who had defended multiple homicides that I had previously investigated.
You mentioned earlier that you have had previous experiences with cell phone devices. What did you see when you downloaded the data from Mr. Brackman?
Well, first I obtained the account data and passwords from his Ring doorbell. I was able to access all files from March 6th, 2020. These videos show the intruder entering.
Let the record reflect that I am showing opposing counsel what has been marked as Exhibit 12. Permission to share screen.
Granted.
Do you recognize this video link?
Yes.
Is this the permission to show video?
Well, tell me which exhibit this is. What number exhibit is this?
This is Exhibit 12, Your Honor.
Exhibit 12. Any objection to Exhibit 12 being admitted and shown.
No objection, Your Honor.
All right, go ahead then, Ms. Inocente.
Your Honor, move to publish to jury.
I thought that's what we were doing, but that's granted. Go ahead.
And what did you do next, Detective Markowitz?
Well, then I downloaded the contents from Mackenzie Brackman's phone and found multiple messages related to something called mock trial. After following up on it, I found out that he had been the mock trial coach for Colorado High School. Based on the number of messages, it seems that he spent more time working with the mock trial team than his actual job as a lawyer.
And where did that lead you?
Well, I followed up on the mock trial activity and I contacted some of the students from his team. The first student I contacted, Alex Cifuentes, gave me a large break in the case. They said that that another student named Avery Becker had just been kicked off of the team and had been wanting to be back on it. Avery Becker stated that
Objection, Your Honor. Narrative.
Again, a little bit of a runaway situation with your witness, Ms. Inocente. Do you agree or disagree?
I agree, Your Honor.
All right. Let's just go question by question, Detective. And your next question is Inocente.
Detective Markowitz, is Avery Becker here today?
yes.
So what did you find on Alex's phone?
Well, when I asked to look at Alex's phone, I found out that they actually didn't have it with them, and they instead sent me screenshots of the conversation.
And what did you do next?
I obtained a warrant to search Avery Becker's phone, but found that they were no longer in possession of it.
Do you know what happened to Avery Becker's phone?
Avery lost their phone on March 5th, 2020. I then got a court order to obtain account records from Becker's service provider and cell tower records for March 6th, 2020.
Did you receive anything else from that information?
I also obtained cell tower records, technically referred to as call detail records, which keep track of messages and calls you send. The record also identifies the cell tower with which the cell phone was communicating, which includes the specific antenna of the tower.
And what did you confirm with these records?
I did confirm that that there were incoming calls from another student named Taylor Perkins, and it was unlikely that Avery had answered because of how short the calls were. If I had lost, excuse me, so sorry. If a phone is turned off or on airplane mode, it stops communicating with cell towers.
And do you know how many calls and texts Perkins sent to Becker?
Yes, between 12:47 and 1:17 p.m., Taylor Perkins called Avery Becker twice and only sent 3 text messages.
Based on the evidence collected and your expert opinion, what do you suspect?
I suspect that Avery Becker went to Mackenzie Brackman's house on Friday, March 6th, 2020, with the thought to break in and vandalize the house in retaliation for Becker getting kicked off of the mock trial team.
The prosecution has no further questions at this time.
All right, thank you. We'll go to cross-examination of the witness, Ms. Bustillos.
Yes, Your Honor. I'll now discuss March 6, 2020 with you. In March, you were assigned to investigate the death of Mackenzie Brackman.
Yes.
You responded to the scene at 14:20 hours.
Yes.
You observed the victim at the front door of his residence,
Yes.
but didn't concern yourself with the body.
Yes.
You looked around the outside of the house,
Yes.
and found a Ring doorbell.
Yes.
The doorbell is a part of the house's security system.
Yes.
The murder was recorded by the cameras.
Excuse me, can you reword that?
The murder was recorded by the cameras. The person that killed Mackenzie Brackman was caught on video by the cameras. You found lots of mock trial related items at his house,
Yes.
but highly doubted it was related to Brackman's murder.
Yes.
If you could please direct your attention to Exhibit 12. I can screen share if that's easier for you if you remember the video. Would you like me to screen share, or is the memory of the video enough?
Would you screen share?
Yeah, absolutely. 1 second. Let me. Okay. Now, in that video, you can't see any identifying factors of the murder.
No, you cannot.
They're covered from head to toe.
Yes.
It is impossible to recognize the person in the video simply by the video.
Other than the figure, no. Or yes.
Okay. I'll now talk about Mackenzie Brackman. He was a criminal defense lawyer,
Yes.
one who you described as being a displeasure to work with.
Yes.
Mackenzie Brackman may have been disliked by some of his clients.
Yes.
Clients he defended as their lawyer,
Yes.
some of which were on trial for murder,
Yes.
some with violent histories.
Yes, I believe so.
So that's a yes?
Yes.
I'll now talk about Alex Cifuentes. The first person you interviewed was Alex Cifuentes.
Yes.
You built the rest of your case based off of what Alex told you.
Yes, it seemed like a good lead.
So that's a yes.
Yes.
Without looking for other possible leads first.
Yes.
Alex told you about the text between them and another student.
Yes.
So you asked Alex to come to headquarters for a full interview.
Yes.
Based on the text between Alex and the other student.
Yes.
Texts that were on Alex's phone.
Yes.
Alex knew you were interviewing him
Yes.
and that you were curious about the messages.
Yes.
Failed to bring their phone to the interview.
Yes.
Which is weird considering Alex is a high schooler.
Yes.
Alex is the first teenager you've encountered who didn't have their phone on them.
Yes.
And this is even more concerning because Alex knew their phone was important.
Yes.
You only got sent screenshots of the exchange
Yes.
and never saw Alex's phone.
Yes.
Not once during the entire investigation.
Yes.
Nothing was done to verify the screenshots were confirmed to be authentic.
Yes.
You have no proof that the images weren't manipulated with.
Yes.
I'd now like to discuss the cell phone data recovery you pulled on Avery's phone. There is no way of knowing who was in possession of Avery's cell phone on March 6th.
That is true.
There were several calls made to Avery's phone,
Yes.
and some texts as well,
Yes.
all from Taylor.
Yes.
The calls were so short that they indicate there was no reply,
Yes.
and the messages weren't returned either.
Yes.
Blair Rowlands, I'd now like to discuss a little bit about Blair Rowlands. Blair Rowlands' house is across from Avery's.
Yes.
If Blair were to go to Brackman's house, Blair would take the exact same route you said Avery would have.
Yes.
The one that matches the cell towers.
Yes.
No further questions, Your Honor.
Thank you. Any brief redirect, Ms. Inocente?
Yes, Your Honor. Detective Markowitz, did you have any reason to suspect Alex Cifuentes?
Yes. Wait, can you repeat that? I'm so sorry.
Did you have any reason to believe that Alex Cifuentes may have doctored the screenshots?
No.
That'll be all, Your Honor.
All right. Thank you. Give us a moment. I want a moment for myself and the scoring panelists to finish with this. Thank you very much, Detective. You may step down. One moment before we get to the next witness, please.
Is there anywhere on the form for comments?
No, you can make separate notes and we can discuss that after we're done with the round and after we put in our score sheets. We can discuss that briefly with the participants a little bit later, Mr. Cassens, okay? We're just putting down numbers at this point, all right? And the panelists are remembering to score each attorney as well as the witness, please. This was witness P1. All right. Are we ready for the next witness, panelist Shoemaker? Thank you. Are we ready for the next witness, panelist Cassens?
Yes.
Thank you all very much. Plaintiff's next witness?
Yes, Your Honor. The prosecution would like to call Alex Fuentes to the stand.
All right, thank you very much. Let's see. Ms. Cifuentes, you've previously been sworn. And Mr. Zia Amati, you may begin your questions.
Okay, thank you, Your Honor. State your name and spell the last for the record.
Alex Fuentes, Sifuentes.
What school do you attend?
Colorado High School.
What year are you in?
I'm a senior this year at Colorado High School.
What year were you in at the time of the murder?
At the time of Coach Brackman's murder, I was a junior.
What was your relationship with Avery Becker?
I was very close friends with Avery. We always had been. We always had been. We were basically best friends.
Did Avery get you into mock trial?
Yes, Avery got me into mock trial. Avery actually convinced me to join my freshman year.
What was Avery like in practice?
Avery was always late to practice without fail.
How did Avery prepare?
Avery never really prepared for anything. Avery was very talented, but not very motivated, and their laziness would always leave the team in a sort of constant state of anxiety.
Did Brackman ever reprimand Avery for her work style?
Coach Brackman would always tell her to do a better job at preparing for practices and tournaments, but Avery would never listen. She basically refused to put in any effort.
Did Avery ever react to this?
Of course, Avery reacted. She would get angry every time Coach Brackman said something to her, even if it was true sometimes. She even got so mad she went and wrote "Where's Attorney Award" on his car.
Objection, this is improper character evidence. The witness is testifying to the state of mind of the defendant.
And response, Mr. Ziamati.
Your Honor, Avery, the witness is saying that Avery reacted and that she did something. It wasn't about the state of mind.
May I respond, Your Honor?
Please.
The witness has just testified that Avery was angry, and under Rule 404, that is improper character evidence, 404A to be specific.
All right. The objection is overruled. I think this is simply a characterization of demeanor and not necessarily reputation for any particular character trait. So I think it conforms with the rules. I'll allow you to continue. Mr. Zia Amati, go ahead.
Okay. Did you see Avery grab a Sharpie when they went to mark up Brackman's car?
Objection, leading the witness.
I can rephrase this statement, Your Honor.
Go ahead.
Okay. Did you witness? What did you see? Hold on a second. What did you see when Avery went to mark up Brackman's car?
I saw Avery grab a Sharpie from the little tool things that we use to write our ideas down on the board. That Sharpie was always there.
Okay. When Avery got kicked off the mock trial team, did she text you?
Yes, she did text me. She asked me to speak to Mr. Brackman on her behalf to try and convince him to let Avery back on the team.
Did you talk to Brackman?
Well, I was excited to be able to have a larger role since Avery would be gone, and I thought the team would be better off without Avery at first, but I still went to Brackman and gave an impassioned plea to let Avery back on the team because in the end, Avery was very talented and we needed that.
Did Avery text you about vandalizing Brackman's house?
Yes, Avery did text me about vandalizing Brackman's house. She actually texted me saying that she was going to go and trash his house.
Let the record reflect that I'm showing opposing counsel what has been marked as Exhibit 14, permission to share screen.
Granted.
Okay. Is this a fair and accurate representation of your text messages with Avery Becker?
Yes.
Your Honor, move to admit Exhibit 14 to evidence.
Any objection? Ms. Mans-Jackson,
No objection, Your Honor.
A14 is admitted.
Your Honor, move to publish to jury.
Granted.
Okay. Did you show the text that Avery sent you to the police?
Yes, of course. I showed the text that Avery sent me to police. I didn't want to rat out Avery, but I couldn't just lie about what Avery said, especially to the police.
Okay. No further questions at this time.
All right. One moment. And cross-examination, Ms. Mans-Jackson.
Yes, Your Honor. Hello, Ms. Cifuentes. My name is Zoe Mans-Jackson. In your statement, you say that throughout your time on the team, Mr. Brackman wasn't happy with Avery for her lack of preparation.
Yes.
You, however, prepared furiously for your mock trial competitions.
Yes, I practice a lot.
But you claim in your statement that despite this difference in preparation, you and Avery were of the same skill level.
Yes, Avery did have a natural talent at mock trial.
And then eventually, though, Avery was demoted to B team.
Yes.
And despite being similarly skilled, you agree with Brackman's decision to demote Avery.
Yes, Avery never prepared and he just didn't deserve to be on the A team.
In fact, you even went so far as to ask Brackman why he put up with Avery.
Yes.
And you asked this multiple times.
Yes.
It annoyed you that Avery was able to just come in and make things up on the spot.
Yeah.
Whereas you used your home time to work on mock trial.
Yes.
In your statement, you even go so far as to claim that Avery won awards based off of looks alone.
Yes.
I'd like to discuss your relationship with Miss Becker. Do you understand?
Yes.
When Avery was kicked off of the team for good, you were ready for the larger role you'd have.
Yes.
You and Avery pushed each other often in mock trial.
Yes.
So much so that in your statement, you say there was a rumor you and Avery were rivals.
Yes.
Let's move a little further down the timeline. You were there on the day that Avery drew on your coach's car?
Yes. Or no, I wasn't. I heard about it.
I'm sorry, you weren't there on the day that Avery?
No.
And that's your sworn statement today?
Yes.
But you also made a statement before trial.
Yes.
You read it and you signed it.
Yes.
And testified to its authenticity there when you were there.
Yes.
But in that statement, you say that you were there at practice the day that Avery drew on the coach's car.
Oh, yes. Yes.
All right, let's go ahead and move on. So yes, you were there on the day that Avery drew on the coach's car.
Yes.
And then Brackman wouldn't let Avery back on the team after that.
Yes.
But personally, you say you believe Avery should have been hit with criminal charges for that accident.
Yes.
Despite that, you say in your statement that you and Avery were best friends.
Yes, we're very close friends, but when somebody does something wrong, you recognize it.
That's a yes.
Yes.
Moving along, you can confirm that Avery was at the Fry Shack on March 5th.
Yes.
And a few weeks ago, someone you believe to be a private investigator came to you.
Yes.
And you didn't speak to her.
No.
Despite having information?
Well, they were basically trying to make a narrative against me that I hated Avery and that I was trying, and I faked the text messages. So no, I did not speak to them.
Okay, so that's a yes, you did not speak to her.
Yes.
You found out, though, that you are being accused of stealing Avery's phone
Yes.
and also of giving it to Blair Rollins,
Yes.
who you went to school with.
Yes.
But you claim you'd never do that.
Wait, can you repeat that? I'm sorry.
In your statement, you claim that you would never do that
Yes.
because you'd never put Mr. Brackman in danger.
No.
So you believe that giving the phone to Blair Rollins could put your coach in danger.
Yes.
Nothing further, Your Honor.
And any redirect, Mr. Zia Amadi?
Yes, Your Honor.
Go ahead.
Okay. Miss Perkins, do you know Blair Rollins well?
No, not at all.
Okay. Was Avery your friend?
Yes, Avery was my friend.
Okay. Did you show the original text messages to the police?
Yes.
No further questions, Your Honor.
All right. Thank you very much. And Ms. Cifuentes, you may step down. Thank you. Give us a moment for myself and the jury to get a breath. All right, and Mr. Shoemaker's ready. Mr. Cassins, you all set?
Yes.
All right. And plaintiff's third witness, please.
Yes, Your Honor, the prosecution calls Kyle Kuzak to the stand.
All right, thank you, Mr. Hernandez. And Mr. Kuzak, you've already been sworn. And Mr. Hernandez, go ahead, sir.
Please state your name and spell the last for the record.
Kyle Kuzak, Kuzak.
And what are you doing here today?
I'm here to describe what happened at the crime scene.
What is it that you do, Mr. Kuzak?
I'm a Colorado Bureau of Investigation crime scene reconstructor, also known as a CSR.
How long have you been a CSR?
For 19 years.
What kind of work does a CSR involve?
I do complex crimes such as homicides, armed robberies, burglaries.
Your Honor, pursuant to Rule 702, based on Kyle Kuzak's experience and training, I ask that the witness be entered as an expert in crime scene reconstruction investigator.
Objections, Mr. Briggs?
A brief word here, Your Honor.
You may.
Mr. Kuzak, you provide no curriculum vitae to the court.
No.
And you list no formal education in your testimony.
No.
In your
Could you
testimony,
repeat the
claim
question?
you list no formal education in your testimony.
No.
In your testimony, you claim to approach your work with a 5-step process. Can you list these 5 steps for the jury?
Yes. Documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and reconstruction.
Your Honor, the defense has no objection to the witness testifying to his opinion, but only in the areas entered as in which he is an expert.
All right. The court will allow the witness to testify as an expert as requested by the plaintiff's counsel. Plaintiff's counsel, you may go ahead.
Mr. Kuzak, before we talk about the case itself, let's go ahead and talk about your work process. If you could,
Yes.
how do you approach a case like this?
Well, previously, like I said, I approach it as reconstruction and documentation, collection of evidence, evaluation of evidence, hypothesis test, and reconstruction.
Could you explain to the court what the first step is?
Yes, I use a witness tracking sheet for my first step. And for my second step, for my second and third step, it's the same as preparing all the evidence that I need to get in an analysis and hypothesis, which that is my fourth step, create an analysis and a hypothesis for this case to come up with a conclusion for my fifth step.
And Mr. What is your final step?
To come up with the conclusion about how this case or what happened on March 6th.
How do you come to your own conclusions in general?
By going over the evidence, looking through, seeing what little details I can find to come up with what happened.
Okay, Mr. Kuzak, now that we know how you do your job, let's go ahead and talk about the case itself. On March 6, 2020, how did you get involved in the investigation of the murder of Mackenzie Brackman?
It was processed by another member of our crime lab.
Your Honor, let the record reflect that I am showing Mr. Kuzak what is marked as Exhibit 10 and permission to screen share.
Yes, please go ahead.
Go ahead and play whenever you're ready. Mr. Kuzak, do you know what this is?
Yes, this is the intruder fiddling with the front door of Mackenzie Brackman's house.
And is this a fair and accurate representation of the ring videos you've seen?
Yeah. Yes.
Your Honor, permission to show. Let the record reflect that I am showing the witness what is marked as Exhibit 11.
The record shall so reflect.
And could you play that whenever you're ready?
Is this a request to play this for the jury? Pause it.
Yes, Your Honor.
Okay. Well, you would, I guess I misunderstood. Your request is to ask that the exhibit be admitted and played to the jury. Is that your request?
Yes, Your Honor.
Any objection, Mr. Briggs?
We have no objection, Your Honor.
Thank you. You may continue where you're at, Mr. Hernandez. Go ahead.
Yes, Your Honor. Mr. Kuzak, do you know what this is?
Yes, this is the intruder on the side gate of Mackenzie Brackman's home.
Is this also fair and accurate of the ring video you have seen before?
Yes.
And Your Honor, permission to share. Let the record reflect that I am showing what has been marked as Exhibit 13.
All right, the record shall so reflect.
Mr. Cusack, what is this?
This is the intruder leaving the front door after getting into a scuffle with Mackenzie Brackman in the home.
And is this a fair and accurate representation of the ring videos you have seen before?
Yes, sir.
Your Honor, move to admit exhibits 10, 11, and 13 into evidence.
Any objection?
We have no objection, Your Honor.
Those are admitted.
And Your Honor, move to publish to jury.
Granted.
Mr. Cusack, what can you tell us about these videos?
So in these 4 ring videos, the first video shows that the intruder comes to the front of the house with the intent to rob it, jiggling the front door to see if it was unlocked. After that fails, the intruder runs to the side gate, which is unlocked, and runs to the back of the house towards the back sliding door. And it wasn't shown, but in the back sliding door, it shows that's where the intruder had entered into the home. And the 4th and final video shows the intruder leaving in the front of Mackenzie Brackman's home.
What can you tell us about the figure?
The figure matches the same height and body, pretty much the same height and same body size as the perpetrator.
Objection, Your Honor. This answer is speculative, which is inadmissible under Rule 7.1 of the competition.
Response, Mr. Hernandez?
Your Honor, based on Rule 703, this is an opinion based on an expert's testimony.
Brief reply, Mr. Briggs?
Yes, Your Honor. While the witness is an expert, identifying a specific individual from nothing but a body shape is would not be considered part of a CSR's typical work.
All right. Well, the jury can decide what to make of it. They understand that I agree with you, Mr. Briggs, that we don't have evidence that he is specifically trained in estimating height and weight and those types of things. But the jury can, I guess, could accept this as lay testimony that any individual could potentially give regarding their impressions upon seeing this. But of course, the jury is the final arbiter here, so it'll ultimately be up to them. So I'll overrule the objection. You can continue, Mr. Hernandez.
Thank you, Your Honor. Did Mackenzie Brackman know about the intruder?
Yes, through Ring, once there's a sensor on the camera, and when something or someone passes by it, it sends an alert to the homeowner's phone.
Let's go ahead and move on. Mr. Cusack, how did Mackenzie Brackman die?
Could you repeat the question?
How did Mr. Brackman die?
Mackenzie Brackman was in a struggle with intruder and got stabbed on his top left shoulder, puncturing his aorta.
And is the stabbing what killed him?
No. Whenever he was stabbed, that knife was used as a plug, stopping it for a little bit, but as soon as Mackenzie Brackman pulled the knife out from his shoulder, the blood then spewed out all on the walls and the floor.
Mr. Cusack, based on your experience and assessment of the evidence shown to you today, what is your conclusion?
My conclusion is the intruder went with the intent to burglarize Mr. Mackenzie Brackman's home and got into a scuffle in the kitchen near the back door. After the scuffle was
Objection,
done,
lack of foundation.
they were.
Response, Mr. Hernandez?
It was the objection for lack of foundation. Is that what it was? Sorry.
Could opposing counsel repeat that question?
Your objection was lack of foundation?
Yes.
Yes, Your Honor.
Your Honor, I'm asking the witness what his conclusion was based on evidence he has seen and
Well, the argument being made here is that the witness is stating conclusions. Everyone all right? You okay? Okay.
Yes, Your Honor, I did cough.
All right, that's fine. The objection is that the witness is now stating conclusions outside of any reasonable facts that have been presented. Do you want to say anything else about that?
No, Your Honor.
That's all right.
Your Honor, if I may, I believe the time is still going.
I understand. Mr. Kuzak, I'll let you continue. The jury will decide whether or not your conclusion are reasonably based on the facts that they've heard. Go ahead.
Could you repeat the question?
Based on experience and assessment of the evidence shown to you, what is your conclusion?
When the intruder walked in through the back door, Mackenzie Brackman was aware and got the alert that the intruder was there. He then grabbed a knife from a knife block, arming himself, getting into a scuffle with the intruder in the kitchen. That scuffle led to the front door, and where the perpetrator or this intruder bear hugged Mackenzie Brackman, got the knife and stabbed him in his top left shoulder, which led to Mackenzie Brackman dying at the front of his house.
Further questioning at this time, Your Honor.
Thank you. Cross-examination, Mr. Briggs?
Yes, Your Honor. Mr. Kuzak, you visited the crime scene.
Yes.
After it was processed?
Yes.
By the crime lab?
Yes.
And you make no mention of ever interacting with any of the tangible evidence in court today?
Yes.
Only photographs, audio, and video?
Yes.
All of these given to you by the police department?
Yes.
I would like to discuss Exhibit 17. Do you understand?
Yes.
Now, Exhibit 17 is the witness tracking spreadsheet you mentioned in your direct.
Yes.
And you created all aspects of this exhibit?
Yes.
You gathered evidence from Taylor Perkins?
Yes.
Or you organized evidence from Taylor Perkins?
Yes.
And from Avery Becker?
Yes.
And you incorporated these into your organizational framework?
Yes.
They influenced your decisions?
Yes.
And neither of these pieces of evidence are available to the jury today?
Yes.
You labeled them 1421 from Taylor Perkins and 141140 from Avery Becker?
Yes.
Objection, Your Honor.
What's the objection?
Assuming facts, not evidence, he's talking about the evidence that has not been submitted at all.
Response?
I'm referring to Mr. Kuzak's process. And it is, I am referring to a document that was brought up in direct.
The court's going to allow it as long as the counsel has a good faith belief in the question. He can ask it. Go ahead.
You wrote that one of the exhibits was a napkin.
Could you repeat the question? I didn't hear the last part.
You recorded that one of these exhibits was a napkin.
Yes.
However, in your official organizational framework, you included no details about the other exhibit. Evidence piece. You organize all evidence into this framework.
Yes.
And this framework is important for your eventual reconstruction.
Yes.
You even include potentially fallible evidence in this framework.
Yes.
On the first page, you list a number of suspects.
Yes.
You list Avery Becker as a suspect.
Yes.
Blair Rollins.
Yes.
And you do list Cifuentes as a suspect.
Yes.
Now I'd like to direct the jury. Oh, no. You also created a chronological flowchart.
Yes.
And you created this in the first of 5 steps to your efficient CSR work.
Yes.
So you created this flowchart before you evaluated the evidence.
Yes.
Now I'd like to move on to some of the physical evidence in this case. Do you understand?
Yes.
You saw photos of blood spatter,
Yes.
but you no longer have these photos.
No, it was corrupted.
Understandable. Now I'd like to discuss the perpetrator we saw in the ring videos. Is that all right?
Yes.
The person in the video is wearing a mask
Yes. Mask and gloves.
and a large jacket.
Yes, it was a blue flannel.
And the perpetrator's fingerprints were not found at the scene.
No, because the perpetrator was wearing gloves.
But they didn't leave any DNA either.
No.
Now I'd like to move on to some of your conclusions. Is that all right?
Yes.
You believe the knife came from the victim's kitchen,
Yes, I believe it came from the knife block.
even though there was an open knife drawer?
Well, if you see from the large knife, the knife missing from the knife block is obviously the larger knife.
But just to clarify, the murder weapon does not look like any other knife in that knife block.
No.
Additionally, the police make no mention of confirming that the knife originated from that knife block.
No, this is just my conclusion. Yeah. No.
For example, they don't even know whether the knife fits in that empty slot.
No.
Now I'd like to go back to addressing this investigation as a whole. Do you understand?
Yes.
You say this seemed like a straightforward home invasion.
Yes.
However, if you remember your chronological flowchart, you list 2 timelines.
Yes.
Timeline A and timeline B.
Yes.
And you still consider both of these to be possible timelines.
Yes.
You were not able to recreate all event segments.
No.
And your conclusion does not account for all of the evidence.
No.
You say you would prefer if you had more evidence at the crime scene.
Yes.
For example, there was no blood spatter until the knife was pulled out, you believe.
Yeah, there was no blood splatter because the knife used was used as a plug.
But if that evidence had been found, it would have helped you locate the exact location where the stabbing occurred.
Yes.
Finally, you reviewed the report of Blake Van Owen.
Could you repeat that? I'm sorry, I didn't hear you.
You reviewed the official report from Blake Van Owen.
Yes.
And some of her conclusions lie outside of your level of expertise.
Yes.
No further questions, Your Honor.
All right, I think it's possible we've run out of time for any redirect for Mr. Hernandez. If I'm mistaken, I'll let the timekeeper let me know. Is it correct, timekeeper? Yeah, okay. So that's going to be all for this witness. You may step down from the stand, Mr. Kuzak. Thank you for being with us today. Attorneys, give us a moment before the next step, okay? Hang on just a minute. All right, and we have a thumbs up from Mr. Shoemaker of the jury, and ready to go, Mr. Cassens. Oh, we have a second thumbs up. We're all set to go. I'm ready to go. And we move on to, I guess I should ask this. Plaintiffs, do you have any additional witnesses?
No, Your Honor, the prosecution rests.
All right, thank you very much. I don't recall if the process allows for halftime motions. I don't think it does. Mr. Briggs, I guess, can correct me if I'm wrong. We're not making halftime motions of acquittal, are we?
No, Your Honor.
Okay, thank you. I get confused between my real life and my mock trial life sometimes. Thanks for helping me out there. And we're going to move on then. The plaintiffs have completed their case. The plaintiffs have rested. We'll move to the defense. And who is the defense's first witness, please?
The defense calls Professor Blake Van Owen to the stand.
All right. Professor Van Owen, you've previously been sworn. And Ms. Mans-Jackson, you may begin when ready.
Before we do begin, Your Honor, may I introduce myself to the court?
Certainly.
My name is Olivia Dalfolo Daly, and I am Professor Blake Van Owen.
Thank you very much. I appreciate that. Let me make sure I can pronounce your name. Ms. Dalfolo Daly.
Yes, Your Honor.
Thank you very much. And again, the name cuts off on the screen, so
I am aware.
you are, let me get to the next sheet of paper here. Defense witness 1 is Professor Van Owen. Owen, no S, Owen.
Yes.
Professor Van Owen, thank you very much for being with us today. You may begin when you're ready, Ms. Mans-Jackson.
All right, please go ahead and state your name and spell your last for the record. Professor Blake Van Owen, Van Owen. And Professor Van Owen, what do you do for a living? I previously worked for the Aurora Police Department, but I'm now a private investigator, a professor, and I've consulted on more than 100 cases. And what is your educational history? I have a master's degree in criminal justice through Ashford University. I've taught a course on police procedures at the Community College of the Rockies, and I've taught a course at CU Denver on police practices and social justice. And are you familiar with courtroom proceedings? Yes, I've testified as an expert witness regularly before in the areas of police practices, crime scene reconstruction, cell tower analysis, and general police investigation techniques. How long have you been in this line of work? I've been teaching for over 5 years. In the average year, I'll handle between 9 and 12 cases that are roughly similar to this one in terms of my time commitments. During an investigation, how do you form your opinions about a case? I review the police reports and investigation by the prosecution. All of my opinions are offered to a degree of reasonable scientific certainty based on my training, experience, and expertise. Your Honor, I move to admit Professor Van Owen as an expert witness in crime scene investigation, cell tower analysis, general police investigation tactics, and forensic evidence techniques as her experience and education qualifies her to give an expert opinion under Rule 702.
Ms. Inocente, objections? You are muted, so let's.
Objections, Your Honor. My
No,
apologies.
yes, okay, thank you very much. The professor will be allowed to testify as an expert in those areas. You may go ahead, Ms. Mans-Jackson.
All right. I'm going to start by asking you about this case in general. What is your connection to the case? I was hired by the Becker family as a private investigator. In your professional opinion, was this investigation conducted in a thorough manner? No, absolutely not. This investigation was rushed. Do you know any of the prosecution witnesses in this case? I professionally know Kyle Kuzak, and I've been in more than one case handled by Detective Markowitz. And do you see Kuzak here today?
Yes, he just testified earlier today and is sitting with the other prosecution witnesses.
Are you familiar with his conclusions?
Yes, I've reviewed the conclusions thoroughly.
And based on your expert evaluation, do you agree with those conclusions?
No.
Why not?
It's clear to me that Detective Markowitz influenced Kuzak's findings. Kuzak's entire report is based on assumptions, such as how the murder happened, where the knife came from, along with misleading cell tower evidence.
And are you familiar with the police gathered evidence in this case?
Yes, I've reviewed it thoroughly as well.
You just mentioned the knife. Can you tell the jury about the relevance of the knife?
Of course. Kuzak saw a knife block missing a knife and a knife wound, and then made the assumption that the two were connected. If he had looked a little closer, he would have seen that the knife brand and size is inconsistent with those in the block and with the knives in the drawer from Exhibit 7. It's just as likely that the murderer brought the weapon on scene.
You also mentioned you disagree with Kuzak on the issue of how the victim was stabbed. Can you explain why?
For Kuzak's theory to work, the intruder would have to be much bigger than the victim. But from the ring video evidence, that's not true. A much more logical explanation would be that the intruder stabbed Brackman in the back while he was seated. This theory also lines up with the autopsy report.
All right, let's move on to talking about the cell tower evidence. Are you familiar with those records?
I am.
And what do those records indicate?
What you have to understand about cell towers is that they don't work like GPS. To say it simply, you could be in an urban environment and make 5 separate phone calls while standing in the same spot, but each of those phone calls connect to a different tower.
So then, in your professional opinion, are those cell tower records accurate?
No. The only physical evidence that the police have that links Avery Becker to the crime is that the lost phone connected to the closest tower. This is definitely not the same thing as Avery actually being at the house.
Is this the only cell phone evidence that you've reviewed?
No, I've also reviewed text message screenshots from Alex Cifuentes' phone.
And what do those screenshots show?
They're only that, screenshots. The police have the technology to download the contents of smartphones. They did no such thing. We can't trust that Alex Cifuentes didn't tamper with them. I take everything with a gallon of salt.
In your statement, you mention a Blair Rollins. Who's Blair Rollins?
Blair is Avery's fellow Colorado high school student.
And does she have a connection to this case?
Well, in addition to the fact that she attended the same school as Avery, Blair's father was represented by the victim, Mackenzie Brackman, in court. In fact, I investigated Blair as an alternate suspect.
And why did you suspect Blair?
She has the same height and build as Avery, and there's no face shown on the ring videos. Blair was also absent from school on the day of the murder and holds a much stronger motive.
You just said a stronger motive. What do you mean by that?
Well, Blair's father, Jonathan Rollins, was found guilty of murder and sentenced to life in prison. Mackenzie Brackman, the victim, was Mr. Rollins' attorney and lost the case.
Have you heard Exhibit 22?
Yes, I have.
Your Honor, permission to screen share a copy of Exhibit 22.
Granted.
And seeing as it is an audio recording, permission to play it one time.
Is this for identification before it's submitted to the jury?
Yes, Your Honor.
Granted.
I'll get you back, Brackman, if it's the last thing I do.
Without going into its contents, go ahead and identify this for me.
This is a tape from Jonathan Rollins' court hearing.
Is it an accurate copy?
Yes.
Is it an authentic copy?
Yes.
Then, Your Honor, I move to admit Exhibit 22 into evidence as its authenticity and accuracy have been shown.
Any objections from the prosecution?
No objections, Your Honor.
All right. I'm sorry, I forgot the name, the designation of the exhibit. What was it?
That would be Exhibit 22.
Exhibit 22 is admitted. You may publish.
All right. So permission is granted to publish.
And we'll assume you've published. Go ahead.
Professor Van Owen, what is happening on this tape?
After the sentencing, with Blair in the audience, Jonathan Rollins threatened to get even with Brackman.
Why is that relevant?
Well, as you just heard, Blair Rollins has a much stronger motive to kill the victim. Her father was sentenced to life in prison because of the actions of Coach Brockman.
Moving on, in your professional opinion, does this investigation establish the prosecution's case beyond a reasonable doubt?
No, the prosecution's case rests entirely on assumption after assumption, inconsistency after inconsistency. Avery has a solid alibi. Their investigation doesn't come close to meeting the burden of proof.
No further questions, Your Honor.
Cross-examination, Ms. Innocenti.
Professor Blake Van Owen, you've conducted your own partial investigation in this case. Is that so?
Yes.
And you believe Blair Rollins to be a more probable suspect?
I do.
But have you ever spoken with Blair?
No, coincidentally, it seems to me that Blair has left the state of Colorado.
So you are unaware of their whereabouts and you've never met them?
Yes.
Do we have any evidence to show that Blair Rollins was in town on the day in question?
I checked school records. Blair was not present at school on the day of the murder, March 6th.
So that's a no.
No.
You spoke of assumptions. Isn't that essentially what you are entailing with Blair Rollins as well?
I believe my conclusions are much more based and have more backing than any conclusions made by Detective Markowitz and Kyle Kuzak.
But once again, you've never met Blair, correct?
I've never met Blair.
No further questions, Your Honor.
Any redirect, Ms. Mans-Jackson?
A brief redirect, Your Honor. Professor Van Owen, what are your conclusions as an expert based on?
My conclusions as an expert are based on my own training, experience, and expertise.
And did your expert evaluation lead you to suspect Blair Rollins?
Yes, they did.
Nothing further, Your Honor.
All right, thank you very much. Give us a moment. I want to remind, at this point, the jury, the panelists, that of course there's a switch when you look at the scoring, so that the direct examination is now on the right, reflecting that's the defense doing the directs, and cross-examination is on the left. There have been a few panelists that have mistakenly reversed those in the past because you've been used to going and noting scores on the left first and the right second. But in this case, you've got the direct examination on the right and the cross-examination on the left. I'm sure both of you are aware of that. I just wanted to make sure. And give me a thumbs up when you're done with your scoring, please. Thank you, gentlemen. And defense, we're going to move on to defense second witness. All right. And Ms. Bustillos, who do we have?
Your Honor, I'll allow the witness, the defense calls to the stand Taylor Perkins, but before time begins, could my witness be allowed to introduce herself for the?
That's fine. All
My
right.
name is Eleanor Briggs. I'm Taylor Perkins, the second defense witness today.
Thank you very much. Sounds familiar. We have another Briggs here on the defense roster. Any relation?
Yes,
We also
Peter
have,
is my older brother.
oh, very good. We also had two Mr. Hernandez. I didn't ask whether or not those two folks were related. I guess we can talk about all that later, though. Thank you. And let me write that down in my slot here. So it's, I'm sorry, the student's name is Ms. Briggs, playing defense witness 2. Hang on a second. Okay, very good. And go ahead then when ready, Ms. Bustillos.
All right. Good evening, Ms. Perkins. Could you please state your name, spelling your last for the record?
Yes, Taylor Perkins, Perkins.
What are your pronouns?
She, her.
What is your connection to the case here today?
I was a senior at Colorado High School along with Avery Becker, my best friend. Avery and I really understand each other, and we have been friends for a long time, so we have a good friendship.
Can you elaborate on your connection to the case here today?
I was on the Colorado High School mock trial team with Avery and Mackenzie Brackman as our coach.
I'd now like to discuss the mock trial team with you. What kind of a teammate was Avery?
Avery was never really prepared, but she didn't have to be. Avery was always still there for the team and was definitely the best lawyer on the team by far.
What were the relationships like with Avery and the rest of the team?
Avery didn't necessarily get along with everybody on the team, specifically Alex Cifuentes and Coach Brackman. Avery never seemed really serious about it though, and she always meant well. It was always just pranks anyway.
How did Avery feel after any scuffles with the team?
Avery would always feel so bad. I mean, I could just tell how remorseful she felt after anything happened. One time that stuck in my head about this was the car incident after regionals. She told me how much she regretted doing it, and it was obvious that she really meant it.
I would now like to discuss Thursday, March 5th, 2020. What happened on that Thursday?
Avery showed up to mock trial practice to try and talk it through with Coach after she'd been kicked off the team, but was told to leave. Avery then came to my house. We hung out and played some games on our phone. Later, we went to the Fry Shack to get some food, but that turned out to be a bad choice.
Why was a Fry Shack a bad choice?
Shortly after we got to the Fry Shack, the majority of the mock trial team came in after they were done with their practice.
Did you interact with the team at all?
Yeah, everybody was telling Avery how unfair it was that Coach kicked her off the team, even Alex Cifuentes. Avery got kind of upset and stormed off to the bathroom. Avery's phone was still on the table, which really showed how upset she was.
I would now like to discuss the specifics of March 6, 2020. Do you know where Avery was on March 6th?
Avery was with me the entire day. She had lost her phone the day before, so we spent the day looking for it.
What happened that morning on March 6th?
Avery picked me up at my house. Avery hadn't answered any of my texts all that morning, and so when I said something about it in the car, we realized that Avery's phone was missing.
What happened next?
We decided to go look for it. We didn't really have to be at school that day, so we went to search for her phone. We retraced all our steps. I called and texted her phone the entire time, but we had no luck finding it.
After Avery picked you up, where did you go?
We first went to the mall and checked every store we had been in the day before. We didn't find it, and I remember Avery leaving her phone on the table at the Fry Shack, so we went there next.
How long did you and Avery spend looking for the phone?
We spent all day looking for it. We spent most of the day at the mall, and then after that we went to the Fry Shack, where the afternoon staff helped us look.
Did anything stand out to you about the Fry Shack?
Not at the moment, but reflecting back to why I'm on the stand in the first place, yeah.
What did you notice?
Well, the mock trial team showed up while Avery and I were looking for her phone.
And why did this stand out to you?
Because they were supposed to be at practice, but apparently Brackman never showed up, so they left after 15 minutes.
Oh,
Now it's weird to think that Brackman was bleeding out while we were talking about him.
Sorry. I'd now like to ask some questions about Blair Rollins. Who is Blair Rollins?
Blair was also a senior at Colorado High School.
What is Blair's friend group?
I'm not entirely sure who Blair hangs out with, but I do know that Alex was pretty close with Blair.
What was the relationship between Blair and Coach Brackman like?
Blair had kind of a thing with Brackman. Brackman was Blair's dad's lawyer in a case a while ago, but Brackman lost the case, sending Blair's dad to prison. Everyone kind of blamed Coach for this, and since then, it's been an issue between Blair and Brackman.
What is Blair's body build like?
It's almost identical to Avery's build. They look very similar.
I just have some final wrap-up questions. Based on your knowledge of Avery, is Avery capable of this?
Avery could be rash or have an inflated ego at times, but Avery was definitely not irrational enough to commit murder. And she definitely couldn't have committed this murder because Avery wasn't there. We were looking everywhere for her phone.
Would you lie for a friend?
Absolutely not. And it doesn't matter what I'm saying because there's proof that I'm telling the truth. There were plenty of people at the mall that saw us and the afternoon shift at the Fry Shack.
No further questions, Your Honor.
All right. Cross-examination, Mr. Zia Amati.
Yes, Your Honor. Taylor Perkins, you were on the mock trial team with Avery Becker.
Yes, I was.
You were a senior at Colorado High School at the time of Mr. Brackman's death.
Yes.
You were Avery's best friend.
Yes.
Avery means a lot to you.
Yes.
You think you and Avery made the mock trial team awesome?
Yeah, especially Avery.
You were good at mock trial.
Yeah.
You were so good you were on the A team.
Yes, I was.
Avery was also good at mock trial.
Yes, even better than me.
But Avery didn't work hard.
No, but she didn't need to.
Brackman didn't like that Avery didn't work hard.
No, he didn't.
Brackman wanted Avery to work harder.
Yes.
Avery got demoted.
Yes.
You were in your senior year at the time.
Yes, I was.
You left mock trial for Avery even though you were good at it.
Yes. She deserved to be on the A team, but more than I did.
You did this so Avery could get back on the A team.
Yes.
When Avery lost her phone, you helped her find it.
Yes, I did.
You skipped school that day for Avery.
Yeah.
You are Avery's alibi for the day of March 6th.
Yes, I am.
No further questions at this time, Your Honor.
Redirect Ms. Bustillos.
Briefly, Your Honor. Ms. Perkins, did other people see you and Avery while you were looking for the phone?
Oh, yeah. There were lots of people at the mall, and all the employees at the mall, too, and the afternoon shift at Fry Shack.
No further questions, Your Honor.
All right, thank you. Thanks for being with us. Ms. Perkins, you may step down and give us a moment, and then we'll be back for the next witness. All right. And we have thumbs up, Mr. Shoemaker. Waiting on thumbs up from Mr. Cassins as well. All right, thank you very much. Okay, and the defense, next witness, please.
The defense calls Avery Becker, the defendant, giving up her right to remain silent to the stand. But before we begin, I'd like a little bit of time for the witness to introduce herself.
All right. And you may go ahead, Ms. Becker.
Thank you, Your Honor and members of the jury. My name is Jaylee Hepner. I am the defendant today, Avery Becker, your third witness.
Thank you very much. Give me a moment to write everything in. Sorry. Ms. Hepner as Ms. Becker. And you're free to go ahead. Mr. Briggs?
Thank you, Your Honor. Please state your name and spell your last for the record, Ms. Becker.
Avery Becker, Becker.
And what are your pronouns?
She and her.
Thank you, Ms. Becker. Can you tell the jury a little bit about yourself?
Yes, I oftentimes love schoolwork. I love the people that go to my school, and I just love the fun of school overall. I usually try my hardest to be the best person I can possibly be or best teammate. I put this in with my favorite activity, mock trial.
And can you please tell the jury a little bit about what being on the mock trial team was like?
Mr. Brackman and I had our differences. However, I proved to be very talented at mock trial, and I really enjoyed it. I loved giving crossings and closings.
Was anyone else in the courtroom today a member of the mock trial team?
Alex, Taylor, and Coach Brackman used to be. I'm sorry, it's really hard to believe he's gone, you know?
Can you please tell the jury who Alex is to you?
Alex and I aren't really friends. We never really got along. We always had kind of a rivalry, but honestly, she was a team member and that's all that mattered.
I'd like to move on to your relationship with Taylor. What was that friendship like?
Our friendship was so good. We are basically tied at the hip, and we were at that time too. I spent all of my free time with her. She's the initial reason I joined the mock trial team, but not the reason I stayed.
And finally, can you elaborate on your relationship with your coach?
Coach Brackman and I, like I said, had our differences. I liked to just go with the flow of the courtroom. Oftentimes I would do a killer cross. I'm sorry, not killer. I meant good cross based off of that. And then I would do a really good closing. But Coach Brackman wanted everything to be done up front and have scripts. This led to a bit of a disagreement.
Can you elaborate on that last statement?
Yeah, he moved me from A team to B team.
And what happened after you were put on B team?
I was really upset. I felt like as a senior and one of the best lawyers on the team, I deserved to be on A. But Taylor told me that the team needed me and that she didn't like mock trial as much as I did. So she stepped down. I kind of forgot about the whole thing, but not what Taylor did for our team.
And how did you do at regionals?
I actually did very well. I won 2 awards, the Best Closer Award and the Best Attorney Award.
Objection, Your Honor.
Yes.
Relevance.
Response.
Your Honor, a significant portion of the people in relation to this case were members of the mock trial team, and how they did at regionals is important to their relationship.
All right, I'll allow it. Jury understands it doesn't go to character per se. Go ahead.
And can you continue with your answer, Ms. Becker?
You may finish.
Yes.
Go ahead, Ms. Becker.
Thank you, Your Honor. Last year, this case was about these 2 old people fighting over their will issues. But when I got the Best Closer Award, I guess you could say that I had them feeding out of my paw because the mom always had this dog she dressed up. So like dogs have paws. And then, I have another one. So I guess you could say I was the best in show because there's dog shows, you know what I mean?
So Ms. Becker, how did Brackman feel about your awards?
Brackman felt differently. He said that I didn't deserve the awards that I got, and I got super upset about it, and I did something really horrible.
Can you please tell the jury what you did?
I wrote worst attorney on the hood of his Porsche with what I thought was a dry erase marker, and it ended up not being.
And how did you feel after you wrote this on his car?
I felt horrible. I offered to pay him back. I offered to buy him a new hood. I offered to take it off, like take the paint off myself, but he wasn't having it. Each time I apologized, he just wouldn't listen. And I wish I had a chance to apologize in person, but I can't, so.
Now let's bring the jury to just before the 6th of March. Can you describe your activities on the 5th?
Yes, I went to go apologize to Coach Brackman again, and he kind of kicked me out of practice. So me and Taylor hung out at her house for a little bit, and then we went to the Fry Shack. We hung out there, saw some mock trial kids, and then we left to the mall.
And what happened the morning of the 6th?
I woke up and realized I didn't have my phone.
And what did you do about that?
I went over to Taylor's house because we do everything together, and she was with me so she could help me look, and we were off to go look for it.
Where did you start?
Well, at first we started at the mall. We looked anywhere and everywhere it could have been. I'm sure we looked in some pots or something. And then we went to the Fry Shack and we looked there and looked at the booths, but we couldn't find it.
And where did you go next?
Well, then we went to the Fry Shack and looked in booths and everything, and it wasn't there either.
Of course. How long did you spend looking for the phone?
We spent the entire day. We skipped school that day and to look for it, and we were still unable to find it.
Did you take any other measures to locate the phone?
Yes. Taylor called my phone several times so we could try to hear the ring, but it was to no avail. We never actually found the phone.
And now I'd like to direct your attention to some of the testimony earlier in the trial. Can you tell the jury about your comments about Markowitz's testimony of the cell phone tower data?
I know that my phone apparently pinged next to Brackman's house. I wasn't near my phone at the time. I lost it, and I have no idea what happened to it. I am not my phone. Taylor and I were across town looking for it. That wasn't me who pinged it.
And do you have a comment about the alleged texts Alex Cifuentes claims were sent from your phone?
Like I said earlier, Alex and I are not friends. We don't get along. I would not have texted Alex, especially if I was trying to break into Brackman's house, which I did not do. I would not have texted her about it ever.
What happened to your phone?
I have no idea. I lost it.
Of course. Now I'd like to discuss Blair Rollins with you. Are you acquaintances with Blair?
I don't really know Blair, but I do know that Alex and Blair hang out quite a bit.
And is Blair in the courtroom today?
No, as I understand, she mysteriously disappeared after Brackman was murdered.
And did you see the ring videos presented by the prosecution?
Yes, I did.
Are you in those videos?
Absolutely not.
Why not?
First off, look at that outfit. I would rather die. I need to stop saying words like that. I'm sorry. I would rather not wear that monstrosity ever. And more importantly, I was across town looking at my phone with Taylor Perkins.
Did you see Exhibit 2 when the prosecution entered it into evidence?
Yeah, I did, but can you screen share it?
Of course. One moment. Ms. Becker, can you describe your reaction to this photo?
It's horrible. I knew he got stabbed in the back, but I didn't imagine it would look like that, you know? I feel so bad for what I did to him, and I'm sorry. Whoever did that is a monster.
Ms. Becker, permission to stop screen sharing, Your Honor.
Sure, yes.
Ms. Becker, did you kill Coach Brackman?
Absolutely not. I wanted to mend our relationship. I felt really bad about the whole car incident. I offered to do a lot of things to help ease and help get back on the team. And I would never have killed him, and breaking into his house wouldn't have helped me do that.
No further questions, Your Honor.
Thank you. One moment. All right. Going to cross-examination, Mr. Hernandez.
Before we start the clock, could I ask for a brief time check?
Time check, please. All right, we're good. And go ahead when ready, Mr. Hernandez.
Hi, Ms. Becker. My name is Chaos. How are you doing today?
I'm good, except I'm on trial for a murder I didn't commit, but otherwise I'm okay.
Ms. Becker, you did mock trial, correct?
Yes, I did.
And you claim that you were good at it?
I was.
You often improvise what you did?
I did, but I just liked going with the flow of the courtroom. That was what I was good at, and that proved to be very useful.
You felt that you were better when you did it. Is that correct?
I'm sorry, can you restate that, please?
You felt better when you improvised.
I wouldn't say felt better. Batman typically would change our scripts, so I kind of just went with the flow of the courtroom.
Was that it? I'm sorry.
I guess that would be a yes.
Okay. Mr. Brockman was your coach, is that correct?
Yes, he was our coach.
You'd stated that he knew how to get you guys to the top?
He was. He actually ended up being a phenomenal coach.
Mr. Brockman didn't like your improv style, did he though?
No, he did not.
And because of that, it caused a rocky relationship?
A little bit, but not a horrible one.
Did you know of Mr. Porsche before the incident?
I'm sorry, can you restate that?
Yes. Did you know of Mr. Brackman's Porsche before the vandalizing incident?
Yeah, he made it pretty known to us that he had a Porsche.
Let's go ahead and move on. You were on the A team last year, is that correct?
Yes.
And during your time on the A team, Mr. Brackman had told you to not deviate?
Yes, he did several times.
A month before the regional competition, you were moved to B team, is that correct?
I was.
And you've stated that the B team was full of losers?
They were full of losers, and I felt like as a senior, I deserved to be on the best of the best, but it doesn't really matter because I got back up anyways.
And that was because you tried, oh, my apology. You tried to talk to Coach Brackman to get back on the A team.
Well, I didn't have to because Taylor Perkins quit for me. So.
But before Taylor
Perkins but for the
quit
team.
For you, but before that.
I'm confused on what you're trying to say.
I'll rephrase. Before Taylor Perkins quit for you, you tried to talk to Coach Brackman to let you back on the A team. Is that correct?
Yes.
And he declined it?
Yeah, he did.
You and Taylor Perkins are friends, is that correct?
Yes.
And you two joined the club together?
Yes, but she wasn't the initial reason I stayed.
Mm-hmm. You two on the team together for 4 years?
Yes.
And after you talked with Taylor Perkins, she quit the team, is that correct?
Well, we were talking and she told me that she felt like I was the best attorney and that the team needed me and that would be the best move for the team since she didn't really like it that much. So I guess that's a yes.
And after she left, you were put back on the A team?
Yes, I was.
So you had gotten what you initially wanted, to be on the A team?
I guess you could say so.
During the regional competition, you improv your closing and cross-examination, is that correct?
Yeah, well, I didn't have an opening, or I'm sorry, I did kind of do that. I had a closing and a cross, but I ended up actually winning 2 awards. So I had a script, but I did deviate from it.
And after the competition, you and Coach Brackman exchanged a series of insults.
Well, Coach Brackman said I didn't deserve my awards, and we went and forth a little bit, but I wouldn't like exchanged insults back and forth. It made me upset, and I left, but it wasn't. Yeah.
Is that a yes or no?
Yes.
Okay. And after you two had talked, you stormed out of practice?
Like I stated, yes.
And before you storming out, you grabbed a marker.
What I perceived as I had a whiteboard marker in my hand, and then I left. I was going to write something down on the board.
The marker was permanent, though. Was that correct?
It ended up being permanent, but as you guys said, the intentions do matter, and I thought it was a whiteboard marker.
And with the permanent marker, you wrote on his Porsche?
Yes, I did. I feel horrible about it.
You wrote worst attorney award. Is that correct?
Yeah, I did.
And after this, you were kicked from the team?
I was kicked off, yes.
You attempted to try to get back on the team. Is that correct?
I tried to, but he didn't let me back on.
Even after various amounts of different ways of trying to communicate with him?
Unfortunately, yeah, but I guess it's what I deserved.
As well as trying to apologize, you were trying to get back on the team. Is that correct?
Yes.
And even still, Mr. Brockman would talk to you?
No, he wouldn't.
You know Alex Fuentes, is that correct?
Yes, I do.
You have claimed that you two are not friends?
We are not.
Did you tried to contact Alex on your behalf? Is that correct?
No, I did not.
You have seen Miss Becker, have you seen the text messages between Alex Fuentes and your phone?
Yes, and those text messages aren't real. So I saw them, but I didn't write them, and so.
Let's go ahead and move on. Ms. Becker, you lost your phone, is that correct?
You said that was all of your question?
No, I'm just moving on from that.
Oh, I'm sorry. Go ahead.
It's all good. Ms. Becker, you've claimed to lost your phone?
I did lose my phone, yes.
And you don't know where you've left it?
I have no idea where it is, no.
You believe it's at the Fry Shack, is that correct?
That's the last time I saw it, but I have no idea where it is, so.
Mm-hmm. You didn't notice it was gone after you left the Fry Shack or any subsequent location?
No, Taylor and I were hanging out and having a good time, and I didn't need to be on it.
You also claim that you were with Taylor the whole morning, is that correct?
I don't claim. I was with Taylor the entire morning.
And you two skipped school, is that correct?
Yes, we did miss school that day.
Ms. Becker, you were showing the ring videos, is that correct?
Yes, I was.
And you're familiar with these videos?
Yes, I am.
Ms. Becker, did you state that you understand that you have a similar build with the figure in the ring videos?
I do have a similar build with the figure in the ring videos, but it wasn't me who triggered the ring videos.
No further question, Your Honor.
Any redirect, Mr. Briggs?
Yes, Your Honor. Ms. Becker, how did you feel after you wrote worst attorney on Brackman's car?
I honestly felt horrible. I should never have done that. It was a spur of the moment thing, and it was not something that I'm proud of. It's one of the worst mistakes I think I've ever made.
Where were you at the time of the murder?
I was with Taylor Perkins the entire day at the Fry Shack and the mall.
No further questions, Your Honor.
All right, thank you very much, Ms. Becker, for your testimony. You may return to your defendant's seat. And does the defense have any additional witnesses to call?
The defense rests its case, Your Honor.
All right, thank you very much. Give us a moment, then we'll proceed to closing statements. The timekeeper can remind the attorneys of the amount of time that they have remaining for those statements. Give us a moment. All right. All right, we have Mr. Shoemaker is ready. Okay. I'm concerned because I'm not seeing Mr. Cassins. I'm probably just missing it. Where is Mr. Cassins? There he is. All right, we're going to find out if Mr. Cassins had an interruption in his connection. Give us a minute. Mr. Cassins, did we have a interruption in your internet connection?
Yes, we did.
And can you tell me approximately when you believe that occurred?
About 30 seconds ago.
All right. Is it after, what was it, after Mr. Briggs finished his redirect questioning?
Yes, it was on cross-exam. No, it was during redirect. My mistake.
During his redirect? Okay.
Correct.
I think Mr. Briggs had only 2 questions. I want to see how much you heard. Mr. Briggs, can you remind me of the 2 questions in order, if you remember them, so Mr. Cassins can tell me what he heard and what he didn't hear? What was your first question? Do you remember?
Of course, Your Honor. My first question was, how did you feel after you wrote worst attorney on Brackman's car?
And you remember the approximate answer?
Well, she felt great remorse and wanted to repair their relationship.
Okay. Do you think you were here for that question and answer, Mr. Cassins?
Yes.
All right. And what was your second question?
My second question was, where were you at the time of the murder?
All right. And the response?
At the Fry Shack and at the mall searching for her phone.
Okay. And Mr. Cassins, do you think you had heard that exchange?
That one I did not.
Okay. So that was the sum and substance of the final question that Mr. Cassins did not hear. I am going to determine that Mr. Cassins heard the vast majority of the witness's testimony, including a small portion, half of the very brief redirect testimony, and I will determine that Mr. Cassins should be allowed to grade that third witness's testimony. We'll keep an eye out, Mr. Cassins, to make sure you're hearing all of the closing. And if a problem develops, we'll deal with it. But at this point, Mr. Cassins, you're hearing us fine? Mr. Cassins is muted. At this point, Mr. Cassins, you're hearing us okay?
Yes.
Very good.
Yes, I am.
Okay. So the panelists will tell me when they have finished their grading of this final witness, including both attorneys and the witness. We've got a yes for Mr. Shoemaker. Waiting on a yes for Mr. Cassens.
Yes.
Thank you very much, Mr. Cassens. We're prepared to move on to the closing statements of counsel. And we'll begin with the plaintiff's closing remarks. And it looks like it's going to be Mr. Zia Amati.
Yes, Your Honor.
Very good. Start when ready. Thank you.
Avery Becker may not have meant to kill her mock trial coach, Mr. Brackman, but it's the thought that counts. Avery Becker planned to enter the house of Mr. Brackman and vandalize it while he wasn't there. As the defense has shown, Avery gets angry easily, and she acts on her instincts. Detective Markowitz, a seasoned detective, carefully examined the evidence and will show us that Avery was clearly the assailant. Alex Cifuentes, a close friend of Avery Becker's, but an honest citizen, showed us texts that she planned on getting revenge on Mr. Brackman. Alex also spoke on the bad temperament of Avery and elaborated on the fact that Avery Becker vandalized Mr. Brackman's car in the heat of the moment. CSR investigator Kyle Kuzak explained the scene of the crime and stated that Avery Becker has a similar build to the intruder in the Ring video. Meanwhile, the defense brought the accused, Avery Becker, and witnesses Blake Van Owen and Taylor Perkins. Loyal to a fault is the only phrase that could perfectly encapsulate Taylor Perkins. Taylor made a huge sacrifice for Avery Becker before when she quit the mock trial team so Avery could be on the A team. Why would Taylor not be there for Avery during her darkest hour? Taylor Perkins is a flimsy alibi at best and a complete liar at worst for where Avery Becker was the day of the murder. Blake Van Owen is a PI who has worked on the defense for 100% of his cases. Then the accused attempted to defend herself. While she was quite emotional, and sometimes in a happy way when she joked about her killer improvisation, her response did not prove she didn't kill Mr. Brackman. The story brought up by the prosecution that Avery and Taylor met the team at Fry Shack on March 6th has not been corroborated by anyone here today except Taylor Perkins and Avery Becker. Avery Becker was there, and the only one who says otherwise is Avery Becker's sacrificial best friend, Taylor Perkins. A friend who sacrificed a day of school for Avery Becker, cares for Avery Becker, a friend who is readily willing to sacrifice for Avery Becker. While it is completely possible that Avery Becker did not mean to murder her coach, Mr. Brackman, it's the thought that counts, and the evidence clearly shows that Avery killed Mr. Brackman. We move to charge Avery Becker with murder in the first degree and second degree burglary of a dwelling. Thank you.
Thank you very much. And you've reserved, it looks like approximately 3 minutes or slightly less for rebuttal. And we'll move to defense closing remarks and Ms. Bustillos.
Yes, Your Honor. Okay.
Whenever you're ready.
Avery wasn't there. She and Taylor were looking everywhere. My name is Jessica Bustillos, representing the defendant Avery Becker in this case. Today we are all here to make sure that justice prevails. You are all warriors of justice, and it is time for you to help keep this system working. And that starts by protecting the innocent. Because Avery wasn't there, she and Taylor were looking everywhere. On March 6th, Avery noticed her cell phone was missing. While someone else was killing Coach Brackman, Avery was with Taylor looking for the phone. She was nowhere near the Brackman house and did not kill her coach. Avery wasn't there. She and Taylor were looking everywhere. It is important to remember jury instruction number 2 while looking at this case. The instruction reminds us that the burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. The prosecution has failed to do that here today, and they have failed for one simple reason. You cannot find an innocent person guilty of a crime they did not commit. Jury instruction number 2 also says, every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The reason these jury instructions exist is because we don't want an innocent person to get convicted. I urge you all to look at the evidence before you and the woman whose life is at stake and to make the right decision. Don't let a wrongful conviction happen here today. The prosecution brought forth 3 witnesses. They called to the stand Detective Jordan Markowitz. Detective Markowitz, an expert in cell phone data analysis, admitted that there's no way of knowing who was in possession of Avery's cell phone on March 6, 2020. Nor can Detective Markowitz confirm the authenticity of Exhibit 14, the text messages. Detective Markowitz also told you of the several calls and texts made to Avery's phone by Miss Taylor Perkins. The calls were so short that could only mean that the calls were not answered, and neither the calls nor the texts were returned. This proves that Taylor was calling Avery's phone in an attempt to locate it, and that Avery wasn't in possession of her phone on March 6th. Detective Markowitz also confirmed that Blair Rowland's house is across from Avery's, and Blair would take the exact same route to Brackman's house, as stated by Markowitz. You also heard from Kyle Kuzak, a crime scene reconstruction investigator who was unable to confirm for a fact that the murderer was Avery. Kuzak was only able to offer to the court that someone with the same general build as Avery killed Coach Brackman, and considering how many people share the same build, it is impossible to find Avery Becker as guilty. Just think, at Colorado High School, there's another person with a near identical build as Avery, that person being Blair Rowlands. They also brought forth Alex Cifuentes, a senior who was also on the mock trial team with Avery and Taylor. Alex failed to provide her phone for the investigation. Considering the modern era and the many ways images can be manipulated, we are forced to reconsider the accuracy of Exhibit 14, the screenshots. Alex has also admitted to not liking the defendant, Avery. This kind of bias could easily be influencing Alex to lie about Avery, and the accuracy of her statement should be taken with a grain of salt. Next, 3 defense witnesses were put on the stand. First, we brought Professor Blake Van Noen, who showed the initial analysis done by Kyle Kuzak and Detective Markowitz was deeply flawed. Blake showed you that the investigation failed to consider other suspects and even manipulated their conclusions to help blame Avery for a crime she didn't commit. Blake not only proved Avery's innocence, but even brought forth a more likely suspect, Blair Rowlands. She showed you an audio clip from Blair's father who threatened Brackman and brought forth the fact that Avery and Blair had a very similar body type. Next, you heard from Taylor Perkins. Taylor confirmed that Avery couldn't possibly have committed this crime, seeing as they were together the entire day looking for Avery's phone. And they weren't alone while looking for it. They were surrounded by the public in both the mall and the afternoon staff at the Fresh Shack. Finally, you heard from Avery herself. You'll see that Avery is a kind-hearted young woman with a bright mind. Avery has made mistakes in her past, but murder isn't one of them. The only thing Avery has ever killed is her mock trial crosses. Avery also confirmed that she was with Taylor all day on March 6th, looking for her lost phone. And she also showed deep remorse for any previous tensions between her and Coach Brackman. Seeing Avery's statement just shows how remorseful she is and how she is incapable of committing this crime. We are all here to let justice prevail, and the way to do that today is to confirm what we all know, and that is the fact that Avery Becker is innocent. Avery wasn't there. She and Taylor were looking everywhere. Thank you.
Thank you very much, Ms. Bustillos, and we'll return again briefly to plaintiff's counsel. Mr. Zia Amati, brief rebuttal, go ahead.
Thank you. The prosecution would like to remind the jury of the following. Avery Becker planned to enter the home of her coach, Mr. Brackman. Avery admitted she shared the build of the suspect in the Reed video. Avery Becker texted Alex Fuentes her friend that she planned on vandalizing the home of Avery Becker. Detective Markowitz is a seasoned detective and carefully examined the evidence when he came to his conclusion, and Kyle Kuzak is a seasoned CSR investigator. The defense continued to float conspiracy theories about Blair Rowlands instead of deciding to combat the fact that Avery Becker was at the scene of the crime. Taylor Perkins lied to the jury today. She continuously sacrificed for Avery Becker, and she did that again today. Taylor Perkins is a friend who loves and cares for Avery. She's a friend who is readily willing to sacrifice for Avery. She's done it before. She did it here again today. Thank you.
Well, thank you very much. My appreciation to all counsel, all witnesses. We're going to finish up our scoring. We are going to submit the score sheets when we have it confirmed by Ms. King, I believe, that everything has been received and accepted by the folks in charge. At that point, we'd like to give you a little bit of feedback, let you know who we are in terms of myself and the scoring panelists, and give you a little feedback. Just a few minutes. I know it's late. Everyone wants to get to dinner and everything else. So we'll finish up our score sheets, and we'll wait for the sign from Ms. King that we can go ahead and debrief. Give us a few minutes. Thank you, everyone. Well done. Panelists are making sure every slot is filled in. All right. The court, including the judge and two panelists, have turned in their score sheets. We're going to wait on confirmation that we have no questions, concerns, or missing information. We'll wait for, I assume, Ms. King to be able to confirm that with us, and then we'll have a chat. Stand by, everybody.
Judge, we are just waiting for one panelist.
Okay, I'm sorry, we're waiting on what?
One panelist.
Okay. So Ms. King, were we the last people to finish or not?
Yes, sir.
We were?
Yes.
I talk too much, obviously.
No, I think it was wonderful.
Have you all been waiting much longer for us to finish than the others?
No, sir, probably about 15 minutes.
Oh, okay.
Not bad at all.
All right. I want to thank the timekeepers also, of course, and all the families that have been watching.
Mr. Shoemaker, are you having any difficulty with your score sheet?
I sent it in.
We haven't received it yet.
Okay.
I'm gonna have to fill out another one because it shows it was submitted.
Huh. Do you have, let's see. So it after you hit submit on the score sheet, it gives you sort of a printed record of it, right?
Yes, I've got that.
Is there a way for him to copy that and email that to the committee, or what's the suggestion for Ms.
Yeah.
King or Ms. Downey?
Mr. Shoemaker, if you can, if you can copy and email it to us.
So it's a PDF, I think. And it looks like you can copy it by highlighting the whole thing, right-clicking and hitting copy. And then maybe you can put it right into an email. And they'll give you an email address.
All right, Mr. Shoemaker, it has just arrived.
Ah.
Thank you.
Well, that's a slow connection.
Yeah.
Can you confirm for us that everything has been filled out? It looks like it's been completely filled out and there's no conflicts noted. Any problems?
I will check that very quickly.
All right.
Sunday, it was missing the name of the student in the defense closing, who was just Jessica Bastillos.
All right.
Unfortunately, Your Honor, I have to disconnect. I've got a house showing.
Okay. Mr. Cassens, any quick things you wanted to tell the students?
I do. I would congratulate them all for doing a fantastic job. I could tell that they've worked very, very hard at this, and they've practiced a lot, especially in a format that doesn't lend itself to doing trials very well. The one thing that both sides did that I wish they would not do is do the phrase, and now we're going to talk about, or some form of that. Just lead in to the next question. And the same also applies with cross-examination on both sides, is a little less testifying and more asking an actual question. But otherwise, overall, excellent job, everybody.
Am I the only one who thinks that Mr. Cassens looks like he's in the witness protection program?
Yeah.
Thank you so much, Damon. I appreciate it. Good seeing you again, sir.
Thank you. Take care, all.
All right. And Ms. King, are we good to go?
You are. Thank you very much, Judge.
All right, thank you. My name is David Gilbert. I've been a judge for 20 years, a district court judge here, handling criminal and civil cases at this time. Before that, I was counsel for almost 20 years. I was prosecutor for much of that time. I've been corporate counsel for a railroad. I've been private counsel in a small firm in Cherry Creek, Denver. So I've ended up handling a whole range of cases, civil and criminal cases, in all different capacities. I was extremely impressed with the hard work that all of you have done here, attorneys and witnesses alike. You knew your case very well on both sides, and it was a pleasure to watch. And like the other panelists, I've for many years, I've watched mock trial, and I'm always surprised and amazed at how well you do, especially under these unusual circumstances. So thank you all. A couple of notes. I love the fact that you know, Ms. Ms. Hepner playing Ms. Becker was playing the part of someone who was a mock trial participant. And I was just curious, like, how did you do the research for that role? Okay.
Very good.
And so I really enjoyed your portrayal. The defendant has got to be one of the most critical pieces of any criminal mock trial process. And it's kind of a delicate role because you want to be relatable and you want to sort of communicate your humanity to the jury so that they can identify with you. And I think you made some strides towards that. Be aware that whenever you try to use humor in these contexts, it can be very hit and miss. So you're always risking turning off some people, and just as you may ingratiate yourself with some people. But I think you did it nicely, and I truly enjoyed it. I wish I had time to give everyone comments. I wanted to specifically appreciate the work of defense witness Professor Van Owen. To me, you really sold your persona in terms of who you were, sort of the uber confident, knowledgeable professor of everything. And there aren't too many things you don't know. And so, yes, there's always the risk that you're overselling your expertise. But I thought you were wonderfully confident and forceful in your portrayal. And I think that's sort of a theme for everyone here. I thought all of you had a very good grasp of what the case was about and the points you wanted to hit. But a lot of this is about your confidence. A lot of it is about how strongly do you portray your character, your opinions, your questions can even be portrayed as confident questions or very hesitant questions, whether it's on direct or cross. And the difference in many trials, both mock trials and real trials, is the confidence of that attorney or that witness, that detective, so on and so forth. And so I'd like to see you all go forward with that kind of confidence like we saw from Professor Van Owen and others of you clearly. I was very impressed with the work of, sorry, give me a second, Ms. Mance Jackson in the manner in which she questioned and in the manner in which she comported herself during the trial. She was an attorney in front of me making a case and not playing an attorney in front of me making a case. And I found it very impressive. But again, kudos to everyone. Very enjoyable to watch, very well done. The work shown through in your performances, and I'm very impressed. And so, Mr. Shoemaker, take it away.
Yeah, I'm Dennis Shoemaker. I'm with the Rotary Club of Colorado Springs. We're about 140 people. We usually meet in person every Friday at the Antlers, but we're meeting every Friday with a Zoom meeting, and we're doing pretty well. We've been supporting I've been doing this for over 20 years, and I enjoy it. And thank you all so much for adapting to the new thing. I'm an old 72-year-old guy sitting in my basement with my computer and mouse and everything, but I kept up with you. I want to pat someone on the back. That's Olivia, the defective witness. You carried that defective thing all the way through, and I picked up on it. And you did so well. And one of the things when I'm in the courtroom watching mock trial is watching the witnesses, and do they stay in character the whole time? And you all did wonderful, and thank you and good luck in future rounds.
All right.
Thank you all. Oh, sorry, Judge, you can go.
Any questions or anything you'd all like to say, Mr. Briggs?
Well, I was just going to take a moment to thank you guys, and I wish I'd done it before the other scorer was able to leave, but we really appreciate you guys taking the time to score this and ultimately allow us to compete this year, because it's something we really enjoy. So thank you for your time.
Great. Any other questions for us? All right. Again, a pleasure. You all deserve a good dinner and a great weekend. And good luck going forward for all of you who go forward. And again, I hope you'll. How many of you have done this before? All right, is that half? Maybe a few more than half. Well, good. I hope you all continue. I think it's a great program, and a lot of you end up appearing in front of me, and I can tell the difference between someone who's worked on this and someone who knows what they're doing and someone who's fumbling into a courtroom. And so I hope to see some of you in court someday, or as my doctor, or as my architect, or as my engineer. I think you have wonderful futures, and good luck to all of you. Thank you very much to Ms. King and to the folks who put all this together as well. This was extremely difficult, I'm sure, compared to other years. It's always a huge undertaking, and this is clearly no different. So thank you. And that's it. Appreciate it. Thanks.
Thank you.
All
Right.
Thanks, Ms. King.